The UK government have quietly released some new and drastic rules that you must meet to qualify for a UK visa, visa extension, and even for settlement. That is for indefinite leave to remain application. And this will take effect from the 11th of November 2025. I really don't know why people are not talking about this as much because it's very important. So please stay with me. Let's go straight into what this new suitability rule means and how this affects migrants. My name is Tochi. You're welcome to my channel. Please like this video, give it a thumbs up as you're watching so YouTube can recommend it to more people, and kindly share it to every migrant that you know because you might be saving somebody. To all my returning subscribers, you guys are amazing. You're welcome back to this video, and if you're yet to subscribe, please click on the subscribe button right now. Thank you. So the government have now introduced something called path suitability, right? So this is basically to check if you are suitable for a UK visa, to stay in the UK, to get settlement, to get your indefinite leave to remain and everything. It's now up to the government to determine if you're suitable to stay in the UK. So that part 9 will now be deleted and be replaced with path suitability. So basically this path suitability rule applies to most visa routes except for some. There are exceptions which have also been listed here, as you can see on the screen. So here begins the grounds for refusal or cancellation of entry clearance to enter the UK or even to stay in the UK. An application for entry clearance or permission must be refused where there is exclusion, deportation order, or travel ban grounds. So where there is an order from the government or Secretary of State to exclude you, when there's a travel ban on you, when you have been banned from entering the UK, where there's also a deportation order or a decision to make a deportation order, Another ground is non-conducive grounds, right? So an application for entry clearance or permission must be refused where the applicant's presence in the UK is not conducive to the public good because of their conduct, character, association, or other reasons, including convictions which do not fall within the criminality grounds, right? So now they're basically looking at your character, your conduct, how you behave, to decide whether you're suitable to remain in the UK, whether you're suitable to get ILR, whether you're suitable to extend your visa and all of that. So you see that this is very, very important, and I feel like we should talk about it more so that people would be aware, right? Ignorance is not an excuse. You won't say, oh, I didn't know, okay? And another thing is where the person's presence in the UK is not conducive to the public good. So what is the character we are looking at? What kind of behavior? How are we supposed to behave? How are we supposed to carry ourselves? What are we supposed to do? So it's quite tricky because the power has been given to the Home Office now to decide who is suitable to stay in the UK. Who they think is suitable to stay. It's a very serious rule. Please, everybody should know this. And that's why you should share this video to as many people as possible, just so that we know exactly what's going on. And also note, this is not an immigration advice or an expert's advice. If you need one, do well to get one. This is just strictly for information purpose, okay? And I'm sharing these documents, and I've shared the source of this document. You can access it if you want. It's the Statement of Changes in Immigration Rules that was released in October 2025. Also, there is exclusion from asylum or humanitarian protection grounds. There's also criminality grounds. So your application must be refused if you've basically committed an offense in the UK or overseas, a criminal offense. You can go through, like I said, feel free to go through it and read up more on these things so that you're more aware and you know everything. Also, involvement in a sham marriage or sham civil partnership grounds. So if you've been involved in a false marriage and you have informed the Home Office about it, and somehow you made them believe that your marriage was genuine, and once the decision maker just decides or has every reason to believe that your marriage was fake or that you were involved in a sham marriage, your application may be denied. And also there's deception grounds as well. Okay, if you've ever made any deception during your application or lied about anything or falsified any document or anything like that, trust me, your application may be denied. So see it here. An application for entry clearance or permission must be refused where the decision maker is satisfied that the applicant used deception, right? This one is another must be refused by making false representations or providing false documents or false information in relation to the application, whether or not relevant to the application, or not disclosing relevant facts in relation to the applications. And also, if your permission was already extended and they find out, it can be cancelled. So just for us to know that if they find out at the point of application, obviously is going to be denied. But even if they've granted it already and they still find out after it has been granted, it can still be cancelled. Now guys, another one is previous breach of immigration law grounds. So if you have breached any immigration law previously and you're making another application, your application must be refused. So this is another one that uses the word must. So basically, where you breached immigration laws, where you breached conditions attached to your permission to stay in the UK, where you illegally entered the UK or overstayed and all of that. So another one is where you fail to cooperate with the redocumentation, arrest or removal process, where you use a false identity, where you use multiple identities, and where you participated in immigration related crimes and all of that. They also define when you will not be treated as an overstayer, so it's here like you made your application within 14 days of your previous permission expiring. See, it's always good to know when your visa is about to expire so that you can extend your stay and apply for a valid visa, else you're going to be seen as an overstayer, because basically you're going to be on no visa. So you're going to be considered an illegal migrant at that point. So just always try to look at your visa, know when it's expiring and know when to reapply, because this is very, very important. It's very, very dangerous if you overstay for even 1 minute. We all saw the case of the Canadian lady that overstayed and how it affected her indefinite leave to remain. So it's definitely going to affect you. So try to keep tabs of your application and make it within the right time frame. So another one is failure to provide the right information grounds. So basically, when you're reasonably required to provide basic information and you refuse, that's going to be a problem as well. If you're required to maybe attend an interview or provide information, provide biometrics, undergo a medical examination, provide a medical report, if you refuse to do all of that, then there's going to be a problem as well. Your application is going to be denied. Another one is admissibility to the common travel area or other countries' grounds. So basically, when you're applying to go to the UK, but your intention is to go somewhere else, which you have not probably stated, then it's going to be a problem as well. Another one is debt to the NHS grounds. See, if you're owing the NHS, there's going to be trouble. So an application for entry clearance or permission may be refused where a relevant NHS body has notified the Secretary of State that the applicant has failed to pay charges under relevant NHS regulations on charges to overseas visitors, and the outstanding charges have a total value of at least £500. So please don't owe the NHS, okay? Unpaid litigation cost grounds as well, right? So where the person has failed to pay litigation costs awarded to the Home Office, there's going to be problem. So if you're also coming into the UK on a purpose not covered by the immigration rules grounds, your application must be refused as well. So on medical grounds, it can be refused. Basically, where a medical inspector advises that for medical reasons, you're not supposed to be allowed to enter the UK, your application is going to be refused as well. It's a lot, so read it. There's no entry clearance grounds. There's failure to produce recognized passport or travel document grounds. There's also consent for a child to travel grounds, right? So a child may be refused permission to enter if they are not traveling with their parent or legal guardian, and if required to do so, the child's parent or legal guardian fails to provide decision maker with written consent to the child seeking entry to the UK. So there must also be written consent if you're traveling with a child. So for returning resident grounds as well, so a person granted settlement may return to the UK where, although having been outside from the UK and Ireland, that permission has not lapsed. The person wants to return to the UK and settle, there's going to be problem. A person granted settlement who is seeking entry to the UK must be refused permission to enter if they fail to satisfy the decision maker that their leave has not lapsed and they do not have entry clearance granted on the appendix returning resident. So there's also customs breaches grounds. So there's also change of circumstances or purpose grounds. There's also ETA grounds, and then rough sleeping in the UK grounds. When I saw this one, I screamed. I'm like, what? See guys, now permission to stay may be refused where the decision maker is satisfied that a person has been rough sleeping in the UK and has repeatedly refused offers of suitable support and has engaged in persistent antisocial behavior. Crew members grounds. This is for those applying as a crew member. You know, so there's also ceasing to meet requirements of rules. So if you fail to meet the requirements of the particular visa that you're applying for, obviously is going to be denied as well. And dependent grounds. So a person's entry clearance or permission may be cancelled where they are the dependent of another person whose permission has been cancelled, right? Because without the main applicant, there's no dependent, okay? And also if there's withdrawal of sponsorship or on endorsement grounds as well. So if your sponsorship or endorsement has been withdrawn, then there's also going to be a problem, okay? So they're also re-emphasizing on that as well, that see, it is very, very important. So they listed so many grounds for students as well, where student does not start course or ceases to study grounds. So if you're on a study visa and you fail to start the course, or then you now stop studying that course, then obviously your visa is going to be cancelled. And when worker does not start work or ceases their employment, your visa will be cancelled. When sponsor loses license or transfers business as well. There are so many of them when you're absent from your employment, because your employment is what is basically keeping you in the UK. We all know that. So change of job or lower salary rate as well is also a problem. So feel free to just go through this, study it thoroughly. This document is public for us to read, you know, and understand everything that is going on, understand how to basically keep up with this, you know. So all these rules are going to take effect from 11th of November 2025. There's also another one that's going to be taking effect from the 24th of November 2025 that I want to quickly show you, and this mostly affects those on study visas. This is it. A student may be self-employed if they have applied for permission on the innovator founder route. So you can now be self-employed on a study route, but you must apply for permission on the innovator founder route. You can only be self-employed if you have applied for permission on the innovator founder route. That application is supported by an endorsement from an innovator founder endorsing body. The application was made when the applicant had permission as a student, right? So you have to make that application when you're still on your study visa, right? And a decision has not been made on the application, or where the application has been refused, any administrative review against a refuser has not been finally determined. Okay, so I just thought to show you guys this because I'm sure some of us missed this as well, right? I said earlier, if you need any expert explanation, or depends on your individual circumstance, you need to see an expert, you know, please do so, because this does not replace it. This is strictly for information purpose. So guys, I want to hear what you think about this in the comment section. Thank you everyone for watching. I'll see you all in my next video. Bye bye.